Welcome back. It was a crime which pushed everything else off the front pages. 3 men, all known criminals, found shot dead in the Essex countryside. It was a cold-blooded, professional killing. The victims had many enemies, but which one wanted them executed?
And welcome back to a new video on the Essex Boys case. As always, if you are enjoying the content, please do give the video a thumbs up. And if you're interested in the Essex Boys case, or simply true crime in general, don't forget to hit the subscribe button below. Claire Carey arrived at Mr. Tate's address to meet him. The lights were on and music was playing. Mr. Tate had left a note saying that he had to pop out for half an hour and asked her to wait. He did not return. The court also heard evidence that the victims had a dinner reservation at the Global Net Cafe in Romford at 20:30 on the evening of the 6th of December. It appears that they intended to attend. The reservation had been rearranged that day. None of the victims attended the restaurant, nor was there any evidence that they had contacted anyone to explain their absence. Point 22. Mr. Steele and Mr. Womes were arrested and interviewed under caution in relation to the murders. They made no substantive replies when questioned. The defence case. Mr. Steele. Point 23. It was Mr. Steele's case that he had been testing his boat rather than importing drugs when he was arrested on the evening of the 8th of November 1995. He had been elsewhere at the time of the murders. Point 24. It was put to Mr. Nichols in cross-examination that it was Nichols who had been importing drugs and that Mr. Steele had only gone with him to Holland to assist him in recovering money. It was put to Mr. Nichols that he had, with the assistance of a corrupt police officer, set up Mr. Steele and Mr. Womes in relation to the murders. Mr. Nichols denied these allegations. Point 25. Mr. Steele gave evidence. He had previously been convicted of importing drugs by plane and served a 9-year sentence. He had bought and adapted the boat but used it for diving. He had not asked Mr. Nichols to obtain a gun for him and knew nothing about the gun found in the loft of his house. The telephone conversations between Mr. Nichols, Mr. Womes and himself on the 6th of December had been in relation to collecting a trailer from one of Mr. Womes' relatives to pick up Mr. Nichols' car that had broken down. Mr. Steele had collected the trailer and then gone home where he saw some people who were interested in buying his house. He had not revealed this to the police when interviewed because he was advised not to answer questions. The defence case for Mr. Womes. Point 26. Mr. Womes gave evidence and denied any involvement in drugs importation or the murders. He had gone out in Mr. Steele's boat on the 7th of November to help test it. He had gone to Ostend with Mr. Steele to help him bring back some money for Mr. Nichols. On the 6th of December, he had gone to collect a car for Mr. Nichols. Mr. Steele had helped him by collecting a trailer to put the car on. He had not answered questions in interviews because he realised that Mr. Nichols was trying to implicate him in the murders and was concerned that if he said the wrong thing, he might implicate himself in something that he had not done. Verdicts. Point 27. Mr. Womes, Mr. Steele and Mr. Corey were convicted of conspiracy to import drugs. Mr. Womes and Mr. Steele were convicted of the murders of Messrs. Tate, Tucker and Rolfe. Mr. Steele was acquitted of possession of the shotgun. Previous appeal history. Point 28. On the 12th of February 1998, Mr. Womes applied for leave to appeal against his convictions. His grounds, which were drafted by counsel, were as follows. Number 1. Severance. The judge was in error and exercised his discretion wrongly in rejecting 2 defence applications to sever the drugs counts from the murder counts. The first application was made prior to trial, and the second to sever the counts and to grant retrials was made at the close of the Crown's case. Point number 2. No case to answer. The judge was in error in refusing to remove counts 2, 3 and 4 from the jury, in that, taking the evidence of the Crown at its highest, no reasonable jury properly directed could safely have convicted on it. Point 3. The evidence of Jasper. The judge was in error in refusing to allow Mr. Womes, through counsel, to ask certain questions of a witness, Mr. Jasper, called by Mr. Steele. Point 4. Mobile telephone evidence. The judge erred in his summary of the mobile telephone evidence and failed properly to assist the jury to assess the significance of this evidence. And point 5. Irrational verdicts. The verdicts of the jury were inconsistent in that the Crown's case on each count relied on the evidence of Darren Nichols. The jury must, in deciding to acquit Mr. Steele of the offence of possession of a firearm, have rejected Mr. Nichols' account. The other convictions that were based on his evidence were inherently unsafe. Section 29. Mr. Womes submitted additional grounds of appeal on his own composition. Section 30. On the 6th of July 1998, the single judge refused leave to appeal against the convictions. Section 31. On the 25th of January 1999, the full Court of Appeal considered and refused a renewed application for leave to appeal. In refusing leave to appeal, the court made the following observations. Severance. The learned trial judge exercised his discretion correctly regarding severance of the counts on the indictment. It would have been artificial to invite the jury to hear the murder counts on their own, since it would have appeared to have been an entirely motiveless crime which they would have found difficult to understand. No case to answer. The court agreed entirely with the trial judge's decision that there was a case for the defendants to answer. Evidence of Jasper. The judge was correct to exclude the evidence that Mr. Womes sought from the witness Jasper, as it was clearly hearsay. Mobile telephone evidence. There was no reason to criticise the way in which the trial judge dealt in his summing up with the evidence of mobile telephone calls. The judge delivered an extremely long, but also extremely fair, comprehensive and neutral account of the evidence. In view of the length of the trial and the degree of care which was devoted to the issues, the court thought it unlikely that the jury were not fully alive to what the issues were. Irrational verdicts. It was not irrational for the jury to acquit on count 5 and to convict on the first 4 counts. The evidence on count 5 was quite different. Section 32. Mr. Womes applied to the Commission on the 15th of May 2002. Following a lengthy review which included a Section 19 investigation, the Commission referred the case to the Court of Appeal on the 15th of December 2004. The case was referred because there was new evidence that, before the trial, Mr. Nichols entered into arrangements with sections of the media whereby he was to be paid or expected to be paid for his story, and those matters were not disclosed by the Crown. In view of the use that the defence could have made of the new evidence in attacking Mr. Nichols' credibility and the centrality of his evidence to the Crown's case, the Commission considered that there was a real possibility that the Court of Appeal would quash the convictions. The Commission also considered there was a real possibility that the Court of Appeal would receive new evidence from a mobile phone expert, David Bristow. Section 33. On the 22nd of February 2006, the Court of Appeal considered the safety of Mr. Womes' convictions alongside those of Mr. Steele and Mr. Corey. The following grounds were argued before the court on that occasion. Point 1. Fresh evidence regarding Darren Nichols' contact with the media undermined the credibility of his evidence and the police investigation. Point 2. Fresh expert evidence from David Bristow regarding the cell site analysis of mobile phone calls made around the time of the murders cast doubt on the safety of the convictions. Point 3. The trial judge misdirected the jury on their right to draw adverse inferences from Mr. Steele's failure to answer questions when interviewed by the police. Section 34. The Court of Appeal upheld the convictions and dismissed the grounds of appeal for the following reasons. Regarding Darren Nichols' contact with the media, Section 35. Quote, First, all the essentials of Nichols' account had been imparted to police officers in interview and reduced to witness statements before he had any dealings with Thompson or any other members of the media. Although the defence case at trial was that what occurred in the interviews was the tip of an iceberg of collaboration between Nichols and Detective Constables Brown and Winston, there is not a shred of evidence to support such a contention. The issue was resolved by the jury, and there is no new evidence to the contrary. Secondly, Nichols' account was long and detailed, and in all important respects it remained consistent throughout. He was in the witness box for almost 3 weeks and was rigorously cross-examined by counsel for all 3 appellants. Thirdly, this was not a case in which the defence had no material with which to cross-examine. The material at the disposal of the defence enabled them to present Nichols to the jury as a time-served criminal of some sophistication, a dishonest drug trafficker, and a man with a corrupt relationship with a police officer. He was plainly a manipulative man with his own interests to serve. He told the jury of the long time he had spent in the company of police officers leading up to the trial, in the course of which they had been anxious that he might fail to come up to proof. Notwithstanding the volume of material which the defence were able to throw at Nichols, the jury remained sure, and unanimously so, about the essentials of his account of the drug importations and the murders. In those circumstances, if the jury had known about the media contacts and Nichols had admitted them as he would have been bound to do, although those contacts are to be deprecated, it is difficult to see how they could have added significantly to the cross-examination armoury in the circumstances of this case. Fourthly, although the jury were convinced by Nichols' account of the essentials of the drug importations and the murders, it is implicit in their verdict of not guilty on count 5, the firearms charge, that they did not accept his evidence about everything. Baroness Kennedy seeks to turn that to the advantage of the appellants by submitting that, in effect, having started down the road to disbelief, the jury might have travelled further with one more push. However, the combination of factors is equally susceptible to the analysis that the jury were prepared to accept Nichols on the drug importations and murders, notwithstanding his many personal shortcomings and in spite of the fact that they were unpersuaded by his account of one of the offences alleged on the indictment. For our part, we consider it virtually certain that the jury would also have rejected that part of Nichols' evidence where he sought to minimise the involvement in and knowledge of the drug importations by his friend Francis Reed. We cannot escape the conclusion that the jury, mindful of Nichols' personal shortcomings and accepting that he had probably not told the truth about, for example, the firearm and Francis Reed, were nevertheless utterly convinced by his account of the essentials of the drug importations and the murders. Fifthly, it is important not to forget the other evidence in the case. Nichols' account of the drugs importations was supported by a quantity of documentary evidence which confirmed aspects of his account, although to the extent that it did so, the appellants also proffered explanations which were consistent with that material. Nevertheless, the evidence of the arrests of the appellants in proximity to the boat on the 8th of November and the finding of a small trace of cannabis in the boat gave some support to Nichols' account. So far as the murders were concerned, the telephone evidence, to which we shall return, was, in our judgment, strongly supportive of Nichols' account. Moreover, although Steele called alibi witnesses, the prosecution succeeded in proving that the alibi was false. Sixthly, even if contrary to the view we have expressed, a reasonable jury might conclude that Detective Constables Brown and Winston had been less than candid in their evidence to this court about their knowledge of Nichols' contacts with Thompson and the media, that does not undermine Nichols' trial evidence to a material degree. Regarding the cell site analysis of mobile phones, section 36. The court heard Mr. Bristow's evidence before deciding whether to receive it under section 23 of the Criminal Appeal Act 1968. Having heard the evidence, the court declined formally to admit it, being satisfied that it was not new evidence. In reaching this conclusion, the court referred to the following points, which rendered the new tests less reliable than the tests conducted for trial. Point 1. When he conducted his original tests pre-trial, Mr. Bristow had not used Mr. Wome's phone, but one of the same make and model. When conducting the new test, Mr. Bristow used Mr. Wome's actual phone, but Mr. Wome's phone may have degraded in the intervening 5 years since the original tests were performed. Point 2. The conditions of the cell site had changed in the intervening 5 years. Point 3. Mr. Wome's phone was an analogue model, and analogue usage had declined markedly in the intervening 5 years, which would alter the conditions. Section 37. Additionally, the court noted that Mr. Bristow stated when giving evidence for the appeal that he remained of the same opinion that he had given at trial. Adverse inference from silence. Section 38. The court accepted that the direction given at trial was different from the direction recommended in the current Judicial Studies Board directions, but noted that a change in the law would not automatically render a conviction unsafe. The court stated that it was, quote, very likely the judge's directions would be different if the matter were to be tried now. However, in the circumstances of this case, we do not think that any injustice whatsoever resulted from the directions which were given. No doubt as to the safety of the conviction is raised in our minds by this point, and accordingly this ground of appeal is also rejected. The applicant's submissions. Section 39. On the 6th of August 2006, Mr. Womes applied to the Commission for a second review of his conviction. Throughout the course of the Commission's review, more than 60 letters have been received from Mr. Womes containing additional submissions in support of his application. Mr. Womes has also provided the Commission with various supporting documents, including 2 expert reports by David Bristow, dated June 2007 and the 14th of July 2009. The Commission has also met with Mr. Womes on 2 occasions to discuss his application, on the 19th of September 2008 and the 1st of June 2010. In addition, the Commission met with Mr. Womes' representative Christopher Bowen at the Commission's office on the 25th of June 2009.